waiting for the end of the board. If your lordship will hear me for 10 minutes, then the bench can be discharged in 1 hour.
Itself has taken longer than 10 minutes.
My lord,
They are all against me. They are all against the all designated lawyers are against me. 99% of the ordinary lawyers support
Let me
me.
start, my lord. Let me start.
my lord, before my friend can start, my lord, there is a, my friend can.
Time be set apart for interveners, especially those representing multiple different religions. And
What will happen? You have given the timelines from your side. I have also done in consultation my sister and brothers some homework on that. Let us see that how it proceeds. Then accordingly we will keep on requesting you.
My lord, I have an urgent mentioning which has got nothing to do with all this.
Oh,
If your lordship, this is a matter which requires serious concern. There is a rape and murder of a 4-year-old child in PS Ghaziabad. Interestingly, though the post-mortem shows aggravated assault, sexual assault, there is no investigation which is directed towards rape. Only an FIR in relation to 302, that too after great persuasion, has been registered. This requires consideration, my lord.
who is the petitioner?
The
parent?
petitioner happens to be the father. The father.
No, who is this?
The father of the child. The father of the child is the petitioner. This way things go on, my lord. No child is safe.
You want to be listed tomorrow? You want to be listed on
Yes, my
Friday?
lord, tomorrow. Tomorrow, day after, whenever your lordship thinks it's appropriate, but it needs urgent hearing.
You will give you choice. If you want tomorrow or on Friday.
What is the prayer?
Friday.
What is the prayer? Listen to me. What is the prayer?
I am seeking transfer of investigations, my lord. There is no investigation which has happened.
Keep it.
That we will consider on merits. Once
Yes.
we list the matter.
Your lordship will have to hear me on merits. I will show to you how things are going on.
We'll have to hear you and then only pass. on.
Yes, yes, yes. Friday, my lord.
Right.
Very good.
Mr. Hariharan, tell your junior to make sure that if defects, if any, that is cured.
It will be cured.
Even if there is, we are listing it on.
Very well. I'm sorry to hold you all up, my lord.
My lord, please have a look at, my lord, my volume, my lord. This is thicker because extractions are there, but your lord did not have to go through the judgments.
They are using electronic copies.
No, no, I'm on. You're sitting there, I need you. So if you can sit there, if you don't. So nice, officer, you. Lord, please come to page 1. Lord, there is something important, my lord, which makes our job a little more responsible, my lord. Lord, your lordships have page 1. Lord, why this is important and why our job is more responsible. It's not, my lord, one particular aspect-centric matter. My lord, please, when the court was, my lord, court has referred the matter to 9 honorable judges. It was, my lord, incidentally authored by Justice Gogoi. Justice Gogoi is the author in Adi Shiva judgment. I'll come to that, my lord, that need not be written. But Adi Shiva judgment takes note of law from Sirurmat till that date, and thereafter when this order is passed, the judgment in Sabrimala was also there. Now, keeping that in mind, please have a look, my lord, why we are before your lordships, my lord, and what is, my lord, the scope of this reference. Para 4. It is time that this court should evolve a judicial policy. It's not, my lord, one judgment being right or one judgment being wrong or one practice, etc. Judicial policy befitting to its plenary powers to do substantial and complete justice and for an authoritative enunciation of the constitutional principles by a larger bench of not less than 7 judges. My lord, why 7 honorable judges? Shirur Math is 7 judge. The decision of a larger bench would put at rest recurring issues touching upon the rights flowing from Article 25 and 26 of the Constitution of India. It is essential to adhere to judicial discipline and propriety, and more than one, my lord, I am not going into it. Only purpose, my lord, is एक chair ले दो, ये रखो. There is a chair. There is a chair.
But give one chair.
No,
please.
there is a chair. I was hinting, my lord,
That
only.
one chair give to Mr. Devan.
There is a chair. Yes, yes. Yes. Now, my lord, your lordships will have to adjudicate and interpret broadly three terms so far as religion is concerned. Article 25(1), I'll come to that, the text, uses the word religion. Second term which is used is Article 25(2), which uses the term religious practices. And Article 26, subarticle B, uses the word to manage affairs relating to religion. Lord, what has happened is, there are Lord, three things which in my submission has happened, and central government is not taking, my lord, one extreme view or the other. I am assisting your lordships what can be the possible way of answering questions and what can be the contours of your lordship's judicial review, which is one of the questions framed. Lord, neither in Sirur Mutt till Lord Sabrimala judgment, my lord, that's the journey of Article 25 and 26. My lord, three things are not noticed. A, the Constituent Assembly debates which brought 25 and 26 into existence. B, Lord, the enormity and width of religions in this country. My lord, we are not dealing with, my lord, one religion. The country is having, my lord, a very proud plurality of religions, Hindus, Muslims, Christians, and other, my lord, Judaism, etc. But the beautiful part is, there is internal plurality in the religions also. Hindu has several sub-denominations. Philosophically, my lord, Hinduism is a way of life. But for constitutional purposes, it is a religion. It is also a denomination. But it is also divided in several denominations. And each denomination has their own independent denomination, which are ultimately referable to the broader concept of Hinduism. Lord, that is, my lord, possibly not presented so far. Same is about, my lord, the Islam. Now, whatever I have studied about the Islam, my lord, the only difference is that it has one particular holy book where you take guidance from and one particular originator. Lord, that is Honorable Prophet Muhammad, which is the distinguishing feature. But even in Islam, there is an internal plurality. It's not all Muslims, my lord, which are, my lord, as a one class, one denomination. There are several denominations. When we, my lord, your lordships will have to examine and answer what is denomination. And the same, so we have Shias, we have
They are occupying chairs.
one young lawyer I requested, but he declined. But anyway, you need not.
Lordship, always the SGs, sir, respected SGs, sir, have me problem. I am in the second line.
I said some seniors are standing.
I am always left my seat, sir.
All right, sir. Yeah, only, but my answer would be a dignified silence. I requested when Mr.
Not only to you, to everyone.
Sundaresh was still standing, I requested him that please give a chair, a very senior member. Anyway, my lord, leave it at that. Any. Lord, the only answer sometimes is the dignified silence. Lord, now, similar is, my lord, Shia Muslims, Sunni Muslims, sub-denominations, etc. And this, my lord, broadly, your lordships are not examining, my lord, theological part of the religion, but must remain in your lordship's mind that Hindu religion is not just Hindus. Islam is not just Islam. Islam has denominations. Christianity has denominations. And this is the beauty of not only pluralistic society in India, but internal plurality, which coexist within the religion also. My Lord, just taking 5 minutes of your lordships, my Lord, this is what, my Lord, your lordships may bear in mind, my Lord, while deciding the word religion, religious affairs, and matters pertaining to religion. My Lord, there is a reason why religious affairs words are used. Earlier, my Lord, it was only religion. But I'll come to that. My Lord, there is a purpose. For example, during the Constituent Assembly debates, it was only matter pertaining to religion. But one of the honorable members said that some matters are not pertaining to religion, but they are religious practices. And he gave an example of Ganpati Visarjan. That it is a part of Hinduism, broader doctrine. But Ganpatya Sampradaya is a separate denomination. It is not. It may not be a part of Ganpatya Sampradaya, but it is a practice followed since at least 300, 400 years. Lord, kindly have a look at Lord, this chart. I will not take more than 5-7 minutes on this point, and I'll switch over to the main points. Lord, this is the width of the term religion, which would, my Lord, be a guiding factor for your lordships to decide to what extent whether a Hindu denomination is before your lordships, or a Muslim denomination is before your lordships, or a Christian or any other religion, to what extent your lordships would have the expertise on the subject, and to what level we will be able to assist your lordships, my Lord. That is an inherent limitation, my Lord, which is subject-specific limitation. Please have a look, my Lord. This is, I have given, my Lord, for Hindu religion. I have also given, my Lord, for other religious, my Lord, religions. My Lord, as we call Sanatana, Sanatan, my Lord, that is Hinduism, we have 4 Vedas. Your lordships are aware: Rigved, Samved, Yajurved, and Atharvaved. It prescribes several things, my Lord. Then we have 4 Upvedas, that is Dhanurveda, Gandharva Veda, Ayurveda, and Arthashastra. Arthashastra may deal with only economic aspects, my Lord, perhaps. Then we have 6 Vedangas. My Lord, this is to preserve and follow the Vedas, which are Shiksha, Vyakaran, Chandas, Niruktas, Jyotisha, and Kalpa. Now we have 4 Upangas. My Lord, one is Dharma Shastra. My Lord, Yagnavalkya and Parashar, my Lord, immediately came to my mind, my Lord. But Patanjali also can be, my Lord, added in this category as per my limited understanding. Then we have Puranas. We have 18 Mahapuranas, 18 Uppuranas, Ramayana, and Mahabharata. Then we have Mimamsa and Nyaya Shastras. Now please turn the page over. It goes further. Mimamsa and Nyaya Shastra, my Lord, which ultimately finds its roots in Vedas, my Lord, has 6 components, and these are recognized components. My Lord, Nyaya, Vaishalika, Sankhya, Yoga, Purva Mimamsa, and Uttar Mimamsa. Correct, my Lord? Kindly mark, my Lord, what I have said. This is Astik Darshan. My Lord, because there is one beauty in this religion. You can be Nastik. You can be a non-believer. You can be an atheist. You can be an agnostic and still be a Hindu. I'll come to that, my Lord, for 2 minutes only. Now, my Lord, we have Uttar Mimamsa mein Upanishads, Bhagavad Sutra, and Bhagavad Gita. Now, Agamas. My Lord, Agamas are the only things which are referred to by Justice Mukherjee, my Lord, my Lord, Justice Venkataswamy in Devaru. My Lord, above that, nothing is, my Lord, discussed. Therefore, my Lord, I am pointing this out. My Lord, 6 Agamas. We have Shakta, Shakti Sampradaya, my Lord, those who believe in Shakti. We have Shaivites. We have Vaishnavites. Then Ganpatya Sampradaya. The Lord Ganesh, Vignaharta, is the deity, is the Ishtadev. Then Kumara, that is Kartik Swami or Lord Murugan. Or Saurya, that is Swami, my Lord, it should not be Swami Narayan, it's a typo. It should be Surya Narayan, my Lord, it's sun god. It's a, my Lord, autocorrect mistake. Kindly correct it, my Lord. It is Surya Narayan.
Difference between the two.
Yeah, yes, your Lord, ladyship is absolutely right, my Lord. And last, and according to me, my personal belief, one of the most beautiful part of this is Nastik Darshans. Nastik means non-believer. They don't believe in God. They don't believe in existence of any superpower. And my Lord, when I was studying this, long back, not for this matter, I was really surprised and I felt proud that Charvak Darshan is dating, my lord, few thousand years, where the world did not have the concept of religion. And Charvak Darshan, in those days, is the first atheist of the world. He did not believe in God. He did not believe in any superpower. He said there is no destiny, there is no person or a body or a power or anything which controls your destiny. The moment, the way a tree exists, a human exists. The tree is destroyed, the human is dead. Nothing happens, no karma, no afterlife, nothing. And there was his following. Charvak had his own following. Charvak Sanhita is still followed by several. Then second is Jaina Darshan. Jain Darshan and Buddha Darshan also, they do not believe in God. Both Jainism and Buddhism, they do not believe in God. They do not believe in afterlife. I'm not, my lord, giving a theological, my lord, background, but this would be necessary. Now, my lord, please have a look at.
Just Mr. Tushar, if you say the Jain and the Buddhists don't believe in afterlife, then where the Tirthankars one after the other reincarnate? There is a belief.
No, Gnostics don't believe one after the other.
No, Jain and Buddhism, you said. You said they don't believe God, but it ends with the death. That's sudden. But they are Tirthankars in Jains, it says that they are reincarnation.
Well, Lord, that is exactly the difficulty, because neither I am competent nor your lordships would be able to know. In Buddhism, what they believe is salvation, moksha, that you are dead,
At last.
you are liberated. There is no afterlife. That's what I say. There is no afterlife. They don't believe in idol worship.
Ideal worship is different.
Probably
Not-
Charvak theory, my brother is giving that example, Rutampi very, but he will share
We
that.
identify pursuit of happiness to John Locke, but it actually relates to Charvak, where Charvak says, Jidam jivat, sukham jivet, rinam kritak, kritam pibat.
Yes, but very popular.
So long as I live with material happiness. Even I will be in debt
I'll
to
consume
achieve
ghee.
the material happiness. So pursuit of happiness in the American Constitution, in fact, relates to
Charvak.
much.
He says whatever is there is in this world. These are all material things you enjoy.
Yes.
Your lordship are right. Even if you have to incur debt, you incur debt but consume ghee. Ghee means consume all which is
Material pleasure.
material pleasure.
So I will go into debt, which spiritually is impure, to achieve the material pleasures of existence.
Material life. Yes.
So it's an existential theology.
Yes.
And we do not require John Locke to remind us.
To mind. Yes.
This is Charvaka.
It is the Charvak, my lord, but some few thousand years back. My lord, answering my lord's question, Lord, they do not believe in afterlife means, my lord, some denominations of Hindu believe that this is only a body. What is the soul is eternal and it only changes the body. From one body, it goes to another body. In Buddhism, there is a concept of nirvana. Nirvana or mahanirvana means once you're dead, you achieve salvation. You literally achieve liberation. You don't reborn. You are not reborn. You don't get a rebirth. That is the concept I'm saying. But that is a non-idol worship, my lord. Lord, I just, my lord, hurriedly conclude this. Thereafter, my lord, comes, my lord, one of the most visionary, my lord, saint who, my lord, walked on this earth. That is, my lord, Adi Shankara, Shankaracharya. Taking into consideration all this, my lord, denominations and non-denominations, he codified Hinduism, or Sanatana as we call, in 10 different sections, which is called Dashanam. Dash means 10, Nam means names. And my lord, what is Dashanam? One is, for example, I'll just give one example, Tirth. Lord, Tirth is one section of that Dashanam. They would have a separate name. If I become a Dikshit in Dashanam Sampradaya with Tirth, then my name would be so-and-so Tirth. You can find out from the name of the saint that he belongs to Giri Sampradaya, Tirth Sampradaya, Bharti Sampradaya, etc., etc. Everyone would have a different tilak. So you identify that he belongs to Dashanam and this particular category. Everyone would have a different salutation for each other. The moment he says Alakh Niranjan, you find out which one of the categories is belong to. But these are 9 categories. 10th category is in what our legal parlance we say residuary entry. Those who do not fall or do not wish to fall in 1 to 9 would be Hindus under the 10th category. It includes non-believers. It includes those who believe in books. For example, Sikhism. Those who do not believe in idol worship and those who do not believe in anything. So I can be a non-believer, non-idol worshipper, and I believe in Charvak theory, but I can still be a Hindu. Lord, this is the broadness of any religion. Lord, your lordships will have to keep in mind. Lord, immediately, my lord, for my lord, I'm not, my lord, getting into beyond a point, my lord, but please have a look at, my lord. This is the my lord, same thing with, my lord, Islam, my lord, that is, and my lord, the main 5 elements are saying, my lord, zakat, etc. My lords would be aware. The holy book is Quran, and Prophet Muhammad is the last prophet, my lord. And my lord, but based upon the doctrinal differences, my lord, page 155, I have given, as per my understanding, these are the denominations which are within one denomination called Islam. But they are all Islam denominations.
155 or
155, my lord.
Just compile it.
PDF 158, my lord, if your lordships are having PDF 158. I'm not, my lord, taking your lordships through this in detail, but Islam, the holy book Quran, then Sunni, Shia, and Khawarij. My lord, Khawarij is now not, my lord, much.
Stable.
Yes. But your lordships need not go in detail into this. My purpose of showing is that let us not take Hinduism, Islam, or Christianity as one particular broad denomination and then take decisions whether it would be a religious practice, whether it is a religion, whether these are affairs pertaining to religion. And therefore, my lord, in section 26B, the framers of the constitution, article, my apologies, I'm not a constitutional lawyer. Article 26B, they have specifically added not only religious affair, any section thereof. So I need, my lord, I'll give you the broadly, my lord, the why section thereof. Kindly have a look at, my lord, the constitution. And there is a purpose and, my lord, a vision of the visionary constitutional framers, my lord. Why as the word section thereof is used. Lord, 26, the first part, my lord. Subject to public order,
where are you referring?
so I'm reading Article 26, my lord. And I'll give the reason, my lord, why our constitutional framers were visionaries and why this expression was specifically added subsequently. Freedom to manage religious affairs. Subject to public order, morality and health, every religious denomination or any section thereof. But what is the purpose? I'll come to that, my lord, in a detail little later. What is the purpose? My lord, suppose, take for example, my lord, Shirdi. Hindus go, Muslims go, all denominations of Hindus go, Shaivites go, Shakti Sampradaya goes, everyone goes. So it is not confined to one particular denomination. It is section of denomination. But for example, Tirupati Balaji. One can say it is a Vaishnavite shrine. One can say it is not a Vaishnavite shrine. It is a Hindu shrine. As Sabrimala says that all are Hindus, all who go are Hindus. So we cannot recognize any denomination. My lord, I'm not arguing that, but Sabrimala does not even consider or refer to the word section thereof. That's a matter of argument at the time of, my lord, review. So, my lord, section thereof, my lord, for example, Khwaja Moinuddin Chishti Dargah. Hindus go, all communities go. which denomination you will, my lord, we will put it, my lord, if there is some question arises. It would be a denomination because it is a part of section of one larger denomination. Khwaja Nizamuddin Aulia. Everyone goes. So there are, my lord, reasons and reasons, my lord, why we cannot blindly and reverentially adopt American doctrines or foreign doctrines, because our religious structure is differently plural, and internal plurality, which gives beauty to it, my lord, has a totally different dimension. And therefore, we did not lift the religious freedom either from the First Amendment of American Constitution or any other constitution. Our framers, though they have adopted some provision in some other articles, 25 and 26 are designed to suit Indian condition.
But Mr. Solicitor, 2526 is an import from the Constitution of
Ireland, yes.
Article 44.
Yes, my lord. But, my lord, it is made or tailored in peculiar Indian situations. It's not word by word thing. That's what, my lord, Dr. Ambedkar also says, that it is derived from in Constitution of Ire, which is Ireland. But Ireland was a theology.
That history of being uniquely Catholic in a Protestant monarchy
Yes.
or an Anglican monarchy.
And Anglican, which, my lord, they used to oppose, and there was rebellions and revolts and etc., etc. So, my lord, and similar, my lord, Christianity, I'm not, my lord, going into it because this is not what your lordships would be essentially. My lord, Buddhism also, my lord, please come to page 160, which is, my lord, the PDF page 160, my lord, 3. I just want your lordships to see the chart that Buddhism is not, my lord, one denomination. That's the, my lord, possibly our lack of assistance, that in all earlier judgments, we never, my lord, pointed out that this is the internal plurality within one religion. So your lordship's view also will have to be, my lord, suitably examined. My lord, Buddha's teachings, that starts, my lord. Then oral traditions, 18 schools were developed. First notion of Mahayana Buddhism, my lord, etc. My lord, Chinese Buddhism is different. Then Vajrayana Buddhism, my lord, which traveled from India, my lord, which is now being practiced. Essentially Mahayana and Vajrayana in Bhutan, Ladakh, Sikkim, etc. My lord, that's not the purest form of Buddhism as Lord Buddha preached. It has, my lord, some element of Matara.
Tantricism.
Yes.
It's a hybrid between Tantricism
Tantrism. It is, my lord, Shaiva Tantrism. The Muni Padma Sambhava in 8th century made a fusion of Buddhism and Shaiva Tantrism, and that is the form of Buddhism which is, my lord, in vogue in Tibet, Bhutan, Sikkim, and other, my lord, areas. So there is an internal plurality, my lord. That's all I am trying to, my lord. Then Vajrayana also, my lord, which has, my lord, next page, my lord, I have given several branches. And, my lord, Christianity, with whatever limited, my lord, understanding I could gather, my lord, because these are general things, my lord, and I have done my own research only to show it is not one thing to say I am dealing with Christianity as a religion. Your lordships will have to decide several things, and the question would be, would the court have the necessary expertise to go into those questions? Your lordships may bear in mind, in most of the cases which we cite for the findings recorded or the ratio. But all those cases came from civil suits. Whether, most of them, whether religious practices, it is a long religion practice, etc., etc. My lord. So, my lord, this is early Christian church, Eastern Orthodoxy, Roman Catholicism, Protestantism, and, my lord, there are some, my lord, sub denominations within one larger denomination. So, my lord, kindly bear this in mind. My lord, in India also, my lord, at page 170, which is, my lord, at 173, I have given, my lord, Indian Christianity also, my lord, year-wise, how, my lord, they have separate denomination. The doctrinal beliefs are same. And one holy book, my lord, that is Bible, that is common. The founder is common, but doctrinal differences, principled differences, etc., interpretative differences also maybe, my lord, a worldly word, my lord. It's not difference, but another way of looking at the same thing. And that is how, my lord, this plural, internally plural religious practices, my lord, develop. Now, my lord, coming back to the main matter now, please have a look at, my lord, something which, my lord, in my respectful submission, subject to being corrected, is missed. My lord, when we interpret Article 25 and 26, which can never interpreted without looking at the preamble. Your lordships have always interpreted fundamental rights in light of the preamble. My lord, at least the judgments which I could see, and I would place some paragraphs, my lord, this part is not specifically noted. Please have a look at page 5, which would be, my lord, 8, my lord, PDF 8. I'm just, my lord, your lordships have read and reread preamble several times, but in this context, only one right, my lord, what we have given to ourselves. My lord, I have highlighted in red color. Your lordships have in red color, my lord. Liberty of thought, we are not concerned possibly. Expression, it can be 19(1)(a) expression or expressing religious belief also, because if we go by egestem generis, expression, belief, faith and worship. This is what is ensured in the preamble. My lord, your lordships may consider, my lord, requiring Article 25 and 26 be interpreted, keeping in mind the faith and belief also. Because there can be several things which are capable of belief system. It may not be emanating, my lord, as a, this is necessary because of the unnecessary doctrine of essential religious practice being introduced. How do you decide? It's a matter of faith. It's a matter of belief. Whether this is essential or this is not essential, you will have to first examine and make a judicial review of religious scriptures. You will have to understand the religious scripture the way it is meant to be understood, which is impossible, my lord, unless we achieve that level of spiritual supremacy. We will also not be in a position to assist what exactly Prophet Muhammad said, or for that matter, my lord, Lord Jesus said, or my lord, the Veda says, or Upanishad says, other things they will say. And based on that, my lord, there can be a faith and belief system which has developed, which is not otherwise contrary to public order, morality, health. And part 3. Then how would your lordships examine the essentiality of that? So that's the purpose, my lord. Now, my lord, coming to how, my lord, the 25 and 26 was framed. And I'll be citing this, my lord, so that it's, I'll have to show the route, my lord, because this was not shown, my lord, earlier to earlier benches, or maybe it has missed or whatever, my lord, I'll not. My lord, the first part is what happened prior to the Constituent Assembly set to debate the draft constitution placed before it. Before that also there were proceedings, there were committees, committees on minorities, committees on religious freedoms, etc., my lord. These are, my lord, also this is, my lord, pre-Constituent Assembly debates, deliberations on 25 and 26. I have confined it to 25 and 26. For completeness, I have placed everything, but I have marked, my lord, what is not to be read because it is irrelevant for the questions to be answered. Now, kindly see at page 10, my lord, PDF 13. This is how, my lord, the first draft was placed by Kanhaiya Munshi. No, the 3 comes there, the subsequent.
It was taken up earlier.
Please, religious and cultural freedom Look, they are discussing 25 to 30. We are not concerned with anything other than 25 and 26. All citizens are equally entitled to freedom of conscience and to the right freely to profess and practice religion in a manner compatible with public order. I'm sorry, page 10 and page 13, my lord, if it is PDF. Printed page 10.
That's it.
Yes. All citizens are equally entitled to freedom of conscience and the right freely to profess and practice religion in a manner compatible with public order, morality, or health, provided that economic, financial, or political activities associated with religious worship. Please underline this. Religious worship was the word initially. Shall not be deemed to be included in the right to profess or practice religion. Your lordships would might, the word propagate is not there. Something turns on that. Therefore, my lord, I am pointing out at this stage. Then, my lord, 2, your lordships can skip. Citizens belonging to national minorities in a state, whether based on religion or language, have equal rights with other citizens in forming, controlling, administering at their own expense, charitable, religious, please mark, this goes ultimately, my lord, in 29 and 30. There cannot be any educational institution of either a linguistic minority or a religious minority, which is educational religious institution. Nothing turns on that for these questions, but I'm just, my lord, pointing out because one of us, my lord, is going to raise possibly the question that 25, 26 applies to educational institutions also. And social institutions, schools and other educational institutions with the free use of their language and practice of their religion. Then no person may be compelled to pay taxes. Well, this becomes Article 27, we are not concerned. Religious instruction shall not be compulsory. This becomes Article 28 in a different format, but we are not concerned. Then no person under the age of 18 shall be free to change his religious persuasion without the permission of his parent or guardian. Conversion from one religion to another brought about by coercion, undue influence, or offering of material inducement is prohibited and is punishable by the law of the union. Please turn the page over, my lord. Then, my lord, Article 2, my lord, there is some. Dr. B.R. Ambedkar independently circulated a memorandum. I have said that. There were 3 drafts, but period, I have said. I'm not as conversant as you, but I have said it subsequently. Yes, yes. Yeah. Continuously I am overhearing you. Dr. B.R. Ambedkar independently circulated a memorandum and draft article. My lord, his draft article was like this. The state shall guarantee to every Indian citizen liberty of conscience and the free exercise of his religion, including the right to profess, to preach, and to convert within the limits compatible with public order and morality. My lord, this was the draft suggested by Dr. Ambedkar. My lord, now please see, my lord, Rajkumari Amrit Kaur and Dr. Hansa Mehta, my lord, 2 eminent lady members. My lord. India, my lord, has always not only, my lord, treated ladies equally, they have always been treated at a higher pedestal. My lord, there are several judgments of the recent past where, my lord, there is a concept of patriarchal society or, my lord, there is some gender stereotypes, etc. They were never there. We are the only generation, arguably, we are the only, my lord, Indian society, we worship ladies. The President of India to the Prime Minister of India to the judges of the Supreme Court, we bow down before our lady deities, my lord. So let us not introduce those concepts of patriarchy and, my lord, gender stereotypes, etc. There has never been. So, my lord, these 2 eminent ladies, Rajkumari Amrit Kaur, my lord, who became the first health minister in Pandit Nehru's cabinet, My lord, they raised
Call them the founding mothers.
founding mothers.
We always say founding fathers.
Yes.
Of the constitution. So let us call these 15 women.
Yes, my lord, founding mothers of the constitution.
Yes.
Correct, correct, correct. Now, my lord, they had pointed out a correct problem.
Ah, yes. These 15 women.
Yes, yes, yes. My lord. It's biographical
No,
narration
participation in the committees,
committee also.
in the assemblies, their contribution and how some of the articles, especially Article 15(3).
And my lord, even 25, 23. My lord, their objection was, apropos your ladyship's, my lord, very right and pertinent observation. Their objection was that if you say right of religion, some religion forbids what otherwise our social reformers have prohibited. For example, somebody may say sati pratha is a part of the religion. Somebody may say child marriage is a part of religion. So he said that you will be nullifying all reformist actions which have been successful by way of laws preventing all this. That was, my lord, a very pertinent objection raised by Rajkumari Amrit Kaur. And, my lord, she says, Article so-and-so of Mr. Munshi's draft was Lord, kindly now turn to page 13. Your PDF page would be 16. My lord, I'm just making a reference. Nothing turns on that for the questions. But Sardar Harnam Singh said that you specifically clarify that right to carry a kirpan is a part of our religion, which was accepted. But that's what, my lord, I have said. Then 27th of March 47, the subcommittee accepted Munshi's formulation of anti-conversion clause, which was clause 7. My lord, same thing which I read, my lord, was accepted. Then, my lord, 31st of March 47, as I pointed out, Rajkumari Amrit Kaur, on behalf of herself and Mrs. Hansa Mehta, wrote to B.N. Rao, my lord, who prepared the first draft. It was Sir B.N. Rao, my lord, dear lordships are aware. Emphasizing that many oppressive practices, that is child marriage, polygamy, untouchability, are justified in the name of religion. They proposed narrowing the right of freedom of religious worship rather than broader practice of religion. My lord, therefore, my lord, she suggested that we should have not have religion, but some other word may be used so that earlier wrong practices may not come back. Your lordships can skip that. My lord, please come to page 14, next page, my lord. First conjoined draft report of the Subcommittee on Fundamental Rights was published. It contained clause 16 and 23 on religious freedoms, including right to profess and practice religion, subject to order, morality and health. Kindly mark propagate was not there. It was only practice and profess. Rights of religious denomination to manage affairs and own property, prohibition on compulsory religious taxes, anti-conversion clauses, that is 22 and so and so. My lord, then see, my lord, 16 is what is 25 today. That's the only thing which needs to be seen, my lord, on this page. All persons are equally entitled. Please see, my lord. These words are introduced for the first time. Now, kindly pause here for a moment. Why am I insisting or emphasizing on this? Lord, Sabrimala judgment reads that equally entitled includes gender equality. My submission is going to be on interpretation. Gender equality is already taken care of in Article 14 and 15. They are equally entitled. For them, it need not be repeated. Why they are saying equally entitled? The framers were aware that we are dealing with a pluralistic society. And, my lord, there is a discussion that one religion may not claim better rights than the other merely based upon the numerical strength. And your lordships would also bear in mind, my lord, the date is 3rd of April 1947, where, my lord, the partition process had started, communal riots were taking place, and the framers of the constitution were aware about the concern that one religion may, based upon the their numerical strength, might try to get something more than the other religions. And therefore, they added the word equally entitled. It has nothing to do with gender. It has something to do only and only with religious plurality of the country, accepting the situation prevailing on that day. Now, my lord, further.
Equally entitled to freedom of conscience.
Yes. So, my lord, everything, my lord, man and women, both are equally entitled to all fundamental rights, which is taken care of in 14 and 15. You need not repeat it. And therefore, it is not repetition on gender basis. It is introduced as a religious freedom so that one religion may not take or may not understand it to have been given more rights than another religion.
No religion is superior than the other.
Than the other, no religion is subservient. All are equal. It is, my lord, manifestation of secularism. It has nothing to do with gender. All persons are equally entitled to freedom of conscience and the right freely to profess and practice religion subject to public order, morality or health, and to other provisions of this chapter. This also comes for the first time. But propagate word has so far not come. Now see the explanation 2. One is, my lord, regarding Kirpan. My lord, we are not concerned. 2. No person, the right to profess and practice religion shall not include any economic, financial, political or other secular activities that may be associated with religious worship. So worship word continues, my lord. Earlier, my lord, what was used was religious worship, which was objected to by Rajkumari Amrit Kaur and Hansa Mehta, but it continued, which is subsequently changed. I'll come to know.
The word worship is there in the preamble also.
Yes, it is there. It is there, my lord. But in the fundamental rights, the objection was this, that if you say religious worship, some of the reforms which we have made might get nullified, because Constitution was being framed as a stage where there were statutory laws prohibiting sati. Sharda Act was, my lord, against child marriage restraint, etc., my lord. So they would refer to Sharda Act also. Sharda Act is, my lord, a name of the act, my lord, based upon the proponent of that act, my lord. But it was child marriage restraint act. And their concern was genuine, but which is taken care of, my lord, subsequently. My lord, now please see page, my lord, 17, the PDF 20, 10.4.47. Earlier, your lordships have noticed state's power to make a law for social reform was not there. It was only subject to public order, morality and health and other provisions of this part. So it was kind of an unqualified right given. Lord, yes, my lord, 8.4.47. Constitutional advice, my lord, that your lordships can skip 14.4.47. Kindly come to the next date. Aladi Krishna Swami Iyer wrote another letter specifically suggesting a clause empowering the state to enact social welfare legislation as suggested by Rajkumari Amrit Kaur and Mrs. Hansa Mehta. The relevant extract is reproduced here and there. Incidentally, Mrs. Hansa Mehta was the wife of first Chief Minister of independent Gujarat when Gujarat was separated. But she was a leader and an intellectual in her own right. She was there in the Constituent Assembly not because she was wife of Jivraj Mehta. Then, my lord, kindly see the bold part.
She has spoken extensively on
Extensively, yes.
how a governor should perform under the constitution.
Yes, my lord. That is where, my lord, the word constitutional morality came. Constitutional morality is I'll come to that. It's a separate chapter. It's a political doctrine as to how government, constitutional functionaries, they should behave, function, work. When there is constitutional silence, then there are certain constitutional conventions. And that convention is known as constitutional morality. But subsequently, in the recent years, constitutional morality left that meaning and became a standard of judicial review, which I'll come to that, which was never conceived. Constitutional morality means this. It's how the constitutionally functionaries should function. And there is a material available that this is how they understood. Dr. Ambedkar also understood it in that context only. The famous speech which is being cited for constitutional morality. To meet the point and then the suggestion is this. To meet the point, an explanation or proviso to the following effect may be added. Now, the suggestion of the Honorable two ladies, my lord, the right to profess and practice religion shall not preclude the legislature from enacting laws of social betterment and of the people. My lord, the wordings change, the spirit, my lord, continued thereafter. My lord. Now it is something else. That becomes, my lord, Article 25 to 2, B particularly. Then your lordships may come to, my lord, next page, 16,447. Now, I am skipping everything which is not relevant, my lord, for your lordships' consideration. And therefore, my lord, I am trying to meet with the report issued with revised clauses on religious freedoms. Clause 16 now guaranteed freedom of conscience, freedom of religious worship, and freedom to profess religion with a significant narrowing from the earlier practice. Clause 17 to 22 addressed denominational rights, religious taxes, etc., etc., my lord. Now, my lord, it becomes religious worship, my lord. Correct, my lords? I am not reading it, my lord. It's only a transient provision which ultimately, my lord, went into some changes. Please come to page 19, my lord, PDF page 22. Lord, this is only, my lord, to complete this. Lord, there were discussions that conversion should be permitted as a fundamental right. And therefore, the word propagate should be added. This is what, my lord, it says. Subcommittee of minorities was formed with Dr. H.C. Mukherjee as the chairman. Mr. Ruthnaswamy pointed out that Christianity and Islam are essentially proselytizing religions, and the clauses should permit them to propagate them. Proselytizing means having the idea of converting people. That was one individual view before the committee. Dr. S.V. Mukherjee noted that the right to build places, we are not concerned, my lord. And then your lordships can, my lord, kindly come to next page, 18,447. Now, my lord, there is a change. The word propagate is introduced in the draft. All persons are equally entitled to freedom of conscience and the right freely to profess, practice, and propagate religion subject to public order, morality, or health, and to other provisions of this chapter. And that explanation to the words religious worship, religious practice should be substituted. Then, my lord, rest may not be relevant, my lord. On the bottom is, my lord, recommendation for anti-conversion, etc. My lord, now come to the next page, 21, lord, PDF page 23. The clauses went for discussion and debate before a larger advisory committee to discussion. The discussion accepted the change or to explanation 2 from religious worship to religious practice. Lord, therefore, my lord, the suggestions were again accepted. Chairman Sardar Patel requested Sri Rajgopalachari and Sri S.P. Mukherjee to draft a comprehensive clause allowing the legislature to intervene to reform and regulate secular affairs. Only secular affairs, Manoj. Their proposal was appending a new explanation stating that nothing in this right to practice religion shall debar the state from enabling laws for the purpose of social welfare and reform, and was swiftly approved. That any religion, the state can make a law for the purpose of reform or social welfare. This was approved, Manoj. The word propagate was taken up at the instance of Ruthna Swami. Munshi and Iyer noted it was already covered by free speech guarantee, but G.V. Pant intervened and said, at worst, it is redundant and it may not harm anyone to adopt it. The word was thus included. Then clause 17, several members including Sardar Patel, Ambedkar, Munshi and Rajgopalachari debated whether legislature ought to be allowed to prohibit religious bodies from holding property. Rajgopalachari offered a middle path, retaining the clause but qualifying it with subject to general law. This becomes 26D in a different format, but the same thing, right to own and administer property, but not an unqualified right as per the law. So the state can make the law. The debate of anti-conversion clause 21 and 22 between Sri S.P. Mukherjee, Bakshi Tekchand, Frank Anthony and Ruthna Swami was settled by Sardar Patel's observation that forced and fraudulent conversion was already an offence under existing statutory law, and the matter was better left to the legislature. My Lord, then, please see, my Lord, next page, K.M. Munshi. My Lord, the rest may not assist your lordships on these questions. There was discussion on this in minorities committee. Many things may not be exactly worship, but maybe in the sense practice of that religion. You may have to, for instance, the immersion procession of Ganpati. It is not worship, but practice of religion. If you go to the temple, it is worship. Further than that, it will be practice of religion. See Rajgopalachari. The second difference is the right of propagate. Propagation comes under freedom of expression. There is a sharp difference of opinion on this, whether worship alone, whether it may be, should be allowed, or whether practice should be included in our fundamental rights. My Lord, it was with a view to whether to widen it or not to widen it. My Lord, eventually, my Lord, it was widened. My Lord, kindly, my Lord, turn to the next page 24. My Lord, I'm not troubling your lordship. Your lordships have been.
Yes.
Did I miss the query, my Lord?
No.
I'm sorry. My Lord, please come to page 24. I'm just, my Lord, shuffling this through, my Lord, because it may not have direct relevance. We'll read 25 textually, and this is how it is interpreted in the judicial pronouncements. Now, my Lord, please come to 27, my Lord, instead of this. My Lord, the rest, my Lord, may not have any. My Lord, this is regarding, of course, conversion. My Lord, the chairman ultimately, my Lord, puts it to vote, and ultimately his decision, somewhere in the 10th or 15th line from the bottom, highlighted part, chairman, I
Consider
these are matters to be left to legislation. With the concurrence of the House, clause 21 was deleted, which provided in a fundamental right chapter that conversion should be prohibited. Sardar Patel says, this is a matter of legislature. It is already a penal offence. Let us leave it to a legislature. We may take up clause 22. This clause 2 is unnecessary and may be deleted. Lord, please see next page, chairman's final verdict. That was forcible conversion. Forcible conversion is no conversion. We won't recognize it. But ultimately he says that there are laws and there can be a law. There need not be a fundamental right either way. Then kindly come to 29.
There is a difference between propagating religion and forcible conversion.
Converting.
Here, what is protected is propagation of religion.
Yes, not by force or inducement or by coercion, etc. That's exactly, I didn't read it, but these were the words used by everyone. That if you are converting someone because of force, inducement, threat, coercion, then it's no conversion at all. You can propagate, you can convince someone, You can say this is the better things of my religion, etc. My lord. Now, my lord, some questions, my lord, your lordships have framed one question. Why was it opened only for Hindus? My lord, Article 25 2b says that all Hindu religious places shall be open. All public religious places of Hindu religion shall be open for all sections. My lord, your lordships would get something, my lord, in this. 1st May 1947. The Constituent Assembly meeting in New Delhi took up Sardar Patel's interim report on fundamental rights. Debate was relatively limited. K.M. Munshi moved to add a specific provision that religious freedom will not prevent laws for throwing open Hindu religious institutions of a public character. I'm reading page 29,
29.
PDF 32.
The top.
I'll read again. The Constituent Assembly meeting in New Delhi took up Sardar Patel's interim report on fundamental rights. Debate was relatively limited. K.M. Munshi moved to add a specific provision that religious freedom will not prevent laws for throwing open Hindu religious institutions of a public character to all classes and sections of Hindus, directly targeting exclusion of Dalits and lower caste from the people. But this was the idea, because we unfortunately were living in a society where one particular part of Hindu was not permitted to be a part of the broader Hindu denomination by denying them right to worship. Again, this had nothing to do with gender. We last decade or so, there is a jurisprudence which is developed where every constitutional provision will have to be seen from the lens of gender. All provisions are not. There is no discrimination. 14, all genders are equal. 15, irrespective of sex, all fundamental rights are equal. This was, my lord, that era-specific provision, that if it is a public temple or public religious institution, it should be open for all. We must do away with this untouchability, etc., section within the section, etc., which was very rightly accepted. I'm highlighting because one judgment has said that this is to ensure that even women can enter. Women were entering all temples. I'll come to that, my lords. Then, my lord, next page, last part. Why section thereof word was used. So far, your lordships have seen Article 25 did not have the word section thereof. It was only religion. Now it comes because K.M. Munshi, my lord, all were visionaries, my lord. Alladi Krishna Swami Iyer, K.M. Munshi. There were many, my lord. If I name, I would be doing injustice to some other people, my lord. But K.M. Munshi, sir, I move an amendment that in clause 14, the word or a section thereof be added between the word denomination and the word shall. It was felt that the use of the term religious denomination may prevent a section of a denomination from being protected. Lord, no judgment has noticed this part. Sabrimala does not notice even the expression section thereof. It says that Sabrimala or Ayyappa Swami is not a denomination at all. That temple is not a denomination because it is a larger part of Hinduism. So no protection under 25-26. Therefore, I gave an example of Ajmer Dargah, where everyone goes. It's a section thereof. In Shirdi, everyone goes. It's a section thereof. In Tirupati Balaji, all Hindus go. Shaivites, Shaktyites, Vaishnavites, everyone goes. But it is a denomination because it takes care of faith and belief of a section of the Hindus. So denomination and a section thereof, that was suggested. And no judgment takes, Lord, at least Sabrimala does not even notice whilst holding that Sabrimala is not a denomination because it is Hindus also go and Muslims also go. And I can give 50 examples of shrines places, dargah, where all community people go, or places where, for example, Dwarka, Srinathji, it is essentially a Vaishnavite denomination. But Shaivites also go, Shakta Sampradaya also go, every Sampradaya goes. Malad. So you cannot say that it is ultimately Vaishnav denomination and therefore it would not get the protection of 25 and 26. Therefore the word section thereof. Page 32. Malad, in this court, Yes, yes. Exactly. Balaji. Lord, I'm sorry, my Lord, if I'm going little. Lord, in case of Dargah committee, my Lord, that is Ajmer, the five judges bench of this honorable court did held that it is a denomination and it is rightly held. One of the reasons why it was referred to was this anomaly. That why, how can you, it's a section thereof. Why are you not doing it? Lord, the only problem with Dargah committee was, for the first time, it introduces essential religious practice doctrine. And it goes to the extent of saying that not only essential religious practice, even superstition is not protected by 25 and 26. Nobody says superstition should be protected, but who will decide whether it is a religious practice or a superstition? Courts certainly cannot decide. If it is a superstition, I'll give your lordships, I have compiled laws which prohibits superstitious acts under Article 25(2)(b), social reform. There are acts, my lord, against black magic, against, my lord, several. I'll give, my lord, the list of laws. So superstition can never be a test for deciding whether it's an essential religious practice. My lord, kindly say practically, if some particular practice comes before your lordships, my lords will have to first decide whether it is a religious practice or not. How can that be decided? You will have to interpret the concerned religious text. Concerned religious text, my lord, would be interpreted by several scholars, my lord, by what we call in, my lord, Hinduism, Bhashya. Bhashya is a commentary, several commentary. If Holy Quran has hadiths, have several other documents, you will have to examine all in juxtaposition and try to understand what is meant when it was written, which is now the sacred text, which is impossible. We also will not be able to assist.
Mehta, are you suggesting that at a certain point of time, at a certain stage, the court may not into the domain of deciding the essentiality, which probably would be a little bit more than the court should be asked upon to interpret?
Lord, I am on a judicial review that this is a domain which may perhaps not fall within the judicial review domain, irrespective of the religion.
There is a difference in the nature of the proceeding in which a question of a religious practice or not an essential religious practice may lie. Don't only see it from the narrow compass of Article 32 or 226. It may be in the form of a civil suit also.
That is one of my submissions. My lord, as I go further, your lordships would find I have not pitched my submission at a higher threshold.
If your proposition is taken to a logical conclusion, then courts are not essentially experts in matters of science, but the Evidence Act empowers the court to examine the opinion of experts and become an expert of experts.
Correct. And take assistance. My lord, that's why one of the
33 or 32 customs, usages, practices. There is a provision in which the law permits the court to use objective parameters to come to correct subjective decisions in the facts of each case as to whether it is a long-standing practice, usage or not.
Probably the difference is here. Science is based upon logic and reasoning primarily. where religion is based upon belief.
Faith and belief. My lord,
Then-
there are two answers, and I'll come
What
to that.
extent we can go into the aspect touching upon belief
Yes.
with a little understanding, as you rightly said, without
I'm going to, my lord, address little in detail on essential practice. Why I highlighted is, first, your lordship will have to decide what is religion. Then second, it would be whether it is essential part of the religion, which would be very, very difficult, and if I am permitted to say, difficult to decide. And third, your lordship will have to say whether this needs examination or not. I have devoted 2-page chapter on this, that even if it is necessary, kindly give me a...
My question is not a opinion in any way. I would just want some.
Understood. No, it's just a...
You enlighten.
Elucidity.
Yes, yes.
My lord, what has happened is, my lord,
Because there is a difference between an opinion as to faith and the faith perceived. One can have a particular faith, but whether that faith, opinion exists in that denomination or not can be separate from the testing of what is the faith itself.
Lord, I would answer, my lord, when I come to that, but my immediate response is this, that...
Because a religious head says, this is my faith, and the followers abide by that. The fact that this is my faith, stated by the religious head, is something which is within the domain of the court to apply the appropriate forensic criteria or tools to decide. But whether that faith actually exists or not is for the religious head.
Rationality or scientific nature of it cannot be gone into. My lord, that's correct. My lord, that's a correct approach. My lord, what I have suggested, my lord, as I go further, my lord, there are two things that your lordships can decide.
We are fully conscious that when we see Article 25, Article 26, it is an unique capsule which must be seen in contradistinction to fundamental duties of scientific temper.
Correct.
Because there may be a faith in the existence of an all-encompassing, omnipotent power, which the scientific temper or scientific experiments may not divulge or unravel as of now. That may not be a question which courts will ever enter into. But whether such a faith existed amongst the members of a particular denomination or a part of denomination can be a issue framed in a suit between two groups or even intergroups.
I'm fully, my lord, in respectful agreement, but not the question whether it is essential part or not. And second, and my lord, I don't want to jump the gun, there is a separate chapter. If it is found to be by a legally trained mind, either unscientific or illogical, only a minute.
Really relevant at all when we come to faith.
Only a minute, my lord. Your lordship finds, my lord, that this is something unscientific, not palatable or something. The remedy is for the legislature under the social reform.
Social, right.
Second, Lord, I have also devoted one chapter that in case if it is required to be gone into whether this is a religious practice at all, the remedy would be a civil suit where the parties can lead evidence, examine expert witnesses, experts on the subject, which will have the court will have the assistance of those expert witnesses, and based upon the totality of the facts, the court would examine whether this is religion or not. It cannot be that there is nothing in affidavit which satisfies us that this is an essential religious practice. That is done. This is a part of judicial review. Therefore, my lord, I'm not, my lord, for a second saying that 32 or 226 would never apply. I'm only on the extent of judicial review.
So we understand your submission is not on justiciability, but the forum at which the
No, justiciability also. And I'll, my lord, make my submission. Yes.
You will make it.
Justiciability also, my lord. That's, my lord. I must make it clear. Lord, it may meet with your lordship's acceptance or not, but justiciability, and in most of the cases, the forum also. Suppose, for example, in some religion, some person claims that right of human sacrifice has been a practice in our religion, and it is an essential religious practice. He comes before your lordships under 32. No evidence is needed. If some example comes before your lordships which directly hits either public order, health, or morality, your lordships would not be required to go into whether it is religious or not, whether it is an essential part or not. And your lordships can say, no, this is contrary to morality. I can have, for example, any, my lord, I don't want to give examples which are immoral examples.
So we take it. So let us take the Sabrimala case. No? Rules are also challenged. There is a forum by which rule can be challenged. So 226, you can always do it. But according to you, if you can reframe what you are saying, the power of judicial review over the constitution the rule is rather limited according to you.
Yes.
To that extent, we can put it.
Yes.
Notwithstanding whether suit is edible, suit also can be filed challenging that.
And it can,
Suit also can be filed.
it can be
But
challenged.
you can say that court should be civil. Certain areas you can venture into, like competency and other things.
Yes,
Like conservation of
legislative
material, those things
competence,
you can enter into.
arbitrariness.
But court cannot substitute itself
Yes.
with the available material, and then how do it can't.
And
can't-
based
can't-
on affidavits,
Yes.
that it is a religion, non-religion. It's not a part of religion.
cannot take the
Whether
role
it
of
is
an expert
essential
and
of
then- you
or
cannot take
not,
the role of expert.
that is, my lord, something, a second guess, which may be done in given circumstances. Suppose cannibalism. Somebody says that cannibalism is a part of my religious practice. It's immoral. No, your lordship doesn't need to undertake any theological exercise. My lord, in Pakistan and some other countries, there are, my lord, the courts, what is called, my lord, ecclesiastical courts, my lord, which are specially, my lord, constitutionally created courts.
Rather we can go into the decision-making process, but not on the decision.
Merit
itself,
review
like
is
just-
not
yeah,
permitted.
okay.
No, that's what, my lord, my
To that
submission.
extent we can.
In a different format, I'll make it good. But in my lord, these courts, which are constitutional federal courts, my lord, the judges are having legal expertise as well as ulemas. They sit together and decide whether it is a part of religious practice and whether, if at all required, it's an essential part of religious practice.
In other words, if there is a social ill which is being branded as a religious practice, the court can certainly distinguish between the two. A social ill or an evil and an essential practice of religion.
My lord, essential practice is a separate issue. But if it is a social evil, the answer can be
Because
yes.
many social evils are given a religious color, but the court can always distinguish it.
Certainly, but the real answer in law, the constitutional answer would be the remedy, even in case of an evil, would be 25(2)(b,
Yes.
which says for social welfare and reform, the legislature can legislate,
Correct.
and there are legislations which I will show that they are the legislatures are, my lord, passing such laws. Well, I'll just, my lord, finish this and, my lord.
Article 25 is a balance between what was existing and what has to be done in future. What has to be done in future is left to the legislature. But the Constitution also tries to preserve what is already existing in Article 25.
I'll go a step further.
One overarching, that is, it is subject to public order, morality, and health when it comes to freedom of conscience, propagating,
And part 3.
and propagating.
And part 3. In 25, part 3. Correct. My lord, even if there is a, my lord, the practice which is in vogue at the time the Constitution came into force, even that can be subject matter of 25(2)(b, reform law, or for social welfare. Something which may be, my lord, good for the society or maybe bad for the society and continued, can still be, my lord, reversed by the legislature by preventing it, regulating it, prohibiting it, whichever way, my lord, the legislative wisdom goes, my lord. Now, my lord, kindly come to page 34. I'm just going to quickly run through and come to, my lord, Sirur Mat. Well, this is conversion, my lord. I'm not reading it. Kindly treat it as read. Lord, ultimately they say, yes, that send back to the advisory committee an advisory committee, my lord, comes back and it says that it is an evil, but it is already penalized and it can be penalized. That's all. Now, please come to page 38, my lord. The PDF would be 41. 41. Now, any class or sections of Hindus. My lord, please bear these in mind right now when I read 25 and 26. My lord, your lordships may have the background why these were added. That's the purpose. This note is our note. Yes. My lord, this is the note which I have said. My lord, this is the note of Sir B.N. Rao. Not note, our note, my lord, in our written submission. It's a note part of the debate, my lord, of the record. The expression any class of sections of Hindus or class section of Hindus used in subsection B of clause 2 of article 19 will not prevent the making of any law for throwing open Hindu religious institutions of a public character to all classes and sections of Hindus. There is, however, no objection to the amendment. Discrimination on the ground of caste, etc., is forbidden by Article 9, which is 17 now. But Sabrimala says that all sections of Hindus were introduced so that it is gender specific. But it is not gender specific. My lord, as a matter of fact, my lord, I'm sorry, but one opinion in Sabrimala says that Article 17 applies to women. You are treating women as untouchables. That's the opinion. One opinion, my lord. That's something I have a very, very strong exception to it. Therefore, I am insisting. All sections of Hindus had the background of all castes, not gender. My lord, India is not that patriarchal or, my lord, gender stereotype society as the West understands. Sometimes that's the problem. It's
the question of untouchability has its own history
yes,
in India, and therefore to get over that, Article 17 was made a fundamental right. Untouchability in the context of the Sabrimala, I don't know how it will be argued.
It can never be justified on untouchability. It can, I'm putting, my lord, that straight.
Speaking as a woman, I can say there can't be 3-day untouchability every month. And on the 4th day, there is no untouchability.
No, I understand. No, I'm not on my lord, menstrual
Let us
cycle.
go by the hard realities.
My lord, but entry of women,
The other aspect is the main question.
we fully agree with this.
And speaking as a woman, Article 17 cannot apply for 3 days. And on the 4th day, there is no untouchability.
My lord, I have no issue or dispute with that. Sabrimala, I'll defend in my own different way. Without, my lord, Sabrimala does not mean 4 days. Sabrimala means a particular age group. And let us be very clear, if there is any confusion in anyone's mind. Lord Ayyappan temples throughout the world are open for all sections of ladies, except one particular section, my lord, temple, my lord, which is a sui generis case. Which is a sui generis case. There are 3 temples, Lord Ayyappa temples, my lord, to my knowledge, my lord, in New Delhi. All, my lord, right from child till, my lord, old women, everyone goes and worships. It is only one temple. Lord, there can be a denomination and denominational practices which we have to respect. Lord, everything is not relatable to human dignity or individual body freedom. My lord, if I go to a mazar or if I go to, my lord, Gurudwara, if I have to cover my head, I cannot say that where is my dignity? You are taking away my right of choice. This is what Sabrimala says. Your right of choice is taken away. Your autonomy is taken away. It's not taking away of the autonomy. It is respecting the tenets, the faith, the belief of that religion. When we go to, my lord, Ajmer Sharif, we do wear, my lord, we do cover our heads. When we go to a Gurudwara, we do cover our heads. And nobody, my lord, says that this is bodily integrity, my lord, which is, but this is, my lord, has snipped in, my lord. There is a new, my lord, jurisprudence which is developed. My lord, I'll bring your lordship's attention to that. But it's saying this, my lord, all sections of Hindus is meant to mean no caste-based discrimination.
That is the first question, Mr. Solicitor. That is the first question. That 26, preserving the right of religious practice or managing religion by a denomination.
Religion affairs. My lord.
Prevails over 25. That is the right of every individual to conscience and to practice. So there is a stratification of 25 and 26, with
Lord.
26 supervening 25 rights.
Lord, there is divergence of view.
So that is what you are trying to, I'm just trying to formulate what you are trying to respond to the first question.
I'll come to that, but immediate answer is this.
Supervening 25.
No, that's not my. Well, therefore, I said I am not raising any of my arguments at a plane which
So
becomes.
far, you have not raised any argument. You are only.
Yes. Yes. It is historical background. But my answer, immediate answer, and I'll finish this. 26B is not a standalone island. It will have to be read with 25 and other parts of the Constitution also. Now, today, my lord, after Coelho, after my lord, TMA Pai, and after R.C. Cooper, we cannot say that any fundamental rights is an island and it cannot take color from any other fundamental right. Article 25 and 26 also will be governed by 14 and 15. That is no gender-based discrimination. I'm not pitching it high. Sabrimala is a sui generis case. On facts, I'll define.
Interesting difference. 25 makes it expressly subject to other.
I'll come to that.
26 is unshackled.
Unshackled.
26 unshackled.
Yes, that is, my lord, a possible view. My lord, but there is a view, my lord, on this side that it should be a separate island. 26 is unfettered by any provisions.
Putting it that high.
I am not putting it. My lord, it would be unfair, my lord, to putting it that high, that one article of any fundamental right chapter can be an island and we can do anything, my lord, we want. That's
not anything. It's subject to moral.
Oh, of course, my lord.
Order and
Not part 3, not part.
health. Definitely not cannibalism, as you say.
Lord, there are some arguments on our side. There are some arguments on our side which says that 26B cannot be read even with 25(2)B. Even there cannot be any law for social reform or, my lord, which takes away 26B, right? Which, according to me, my lord, is too high, my lord, interpretation, my lord, to be given. Now, my lord, I'm through with, my lord, this. I'm not, ultimately, my lord, it comes to what 25.
Mehta probably will have to also address, because we should not stretch the consideration to a point where we consider all Lord Ayappa temples in one frame. This has to be specifically with only one. As you said, that all others, this is not the restriction. It is only in one special temple.
That's not, my lord, my submission. My submission is that 25 and 26, as my lords have used the word, is a capsule. It will have to be read together, and 26 also may take color from other fundamental rights. I am saying.
I'm not with what Brother.
I'm only saying Sabrimala is a sui generis specific case. There may be other temples having their temple specific peculiarities.
So this has to be specific to that.
I'm saying Sabrimala, I'm not right now touching. It's a sui generis case, my lord. I'm not saying there may be other temples also, my lord, where there are for example, this is attribute of a deity. In Ayappan Swami case, it's an attribute of a deity. Lord, how would we judicially examine? Can an attribute of a deity be ever subject matter of, Lord, a judicial? With that, I'll come to that. Please come to.
It's not a mere practice. It is connected to the belief.
Faith and belief both.
So it will be a little bit more.
Yes, my lord. Lord, therefore, kindly now come to 25 and 26, and then I'll directly come to Lord Shirur Math. Okay. My lord, 25. First, see, my lord, the title of the chapter, Right to Freedom of Religion.
If we could be also, I will give you an answer for your apprehension. It's the, I think.
Lord, the title of subtitle of part 3 is Right to Freedom of Religion. Correct? Now 25. Freedom of conscience and free profession, practice and propagation of religion, subject to public order, morality and health, and to other provisions of this part. Lord, it is specifically made subject to part 3. All persons are equally entitled, equally is a manifestation of secularism, I have said, to freedom of conscience and right freely to profess, practice, and propagate religion. So, first word which is used is religion. Then, 2. Nothing in this article shall affect the operation of any existing law or prevent. Am I with your ladyship, my lords?
Prevent the state from.
Yes, ma'am. Nothing in this article shall affect the operation of any existing law or prevent the state from making any law, A, regulating or restricting any economical,